thank everyone for being here for Change My Name, the Law for Lunch webinar, CLE. I'm Tom Keller. I'm a member of the CLE committee, family law committee, solo and small practitioners. I'm a child support referee and a divorce lawyer in Sioux Falls. We have two wonderful speakers with us today. Megan Joyce is a partner at Redstone Law Firm here in Sioux Falls. She is the team lead of the employment law group and a member of the litigation group. She also does construction law, trust litigation, and appellate work. She's a poli-sci grad from USD and USD law, clerk for Justice Severson, and has been in private practice since. Member of Women in Law Second Circuit Bar, Trial Lawyers Defense Lawyers Association, the Sioux Falls BPW. She lives with her husband, 3 kids, and a dog. Our other speaker, and I'm just going to introduce both of them now so they can roll right from one to the other, is Professor Hannah Haxgard. She's a professor at the University of South Dakota Knudson School of Law, teaches property law and family law, and also writes on those topics, as well as a particular interest in the rural lawyer shortage. She grew up outside of Yankton, South Dakota, did her undergrad at Kentucky and her JD from Berkeley. She, and this is a particular interest to me as a member of the Board of Historic Preservation of Sioux Falls, lives in a 1902 colonial revival, which is individually listed on the National Register of Historic Places, with her husband, 2 kids, and 2 cats. I am excited for the program today. And the only other comment I would make, the one practice tip I have gotten in 35 years of doing this is know what the legal publications are in your county. Oftentimes you will discover it is much more cost effective to publish in the Del Rapids paper than the Sioux Falls Argus Leader, and saves your clients lots of money if they do have to go through the process of actually going through a formal name change, including publication. With that, thank you. Professor, Ms. Joyce, take it away.
Thank you, Tom. I'm going to start today, and I'm going to just thank you to the State Bar for having me to talk. One of the things that interests me is name change at marriage. So I'm going to be talking about changing your name on the marriage license at the time you get married. Before I get into the South Dakota Code on this issue, let me provide some background information about how the law has transformed over the decade. Under the common law, a woman assumed her husband's name when she got married. This has been true since the 13th century in England, when women began changing their surname at the time of marriage. American women adopted this custom, but it was never strictly required under the common law. However, by the 1800s, a few states started conditioning rights on women using a husband's last name. Those requirements stayed on the books for over a century. Then in the 1960s and 70s, increasing numbers of married women started to retain their maiden names after marriage. During the 70s and 80s, hyphenating both last names became another popular option. Women challenged these laws and policies by bringing lawsuits and proposing legislation that would specifically authorize married women to retain their maiden names. And in this sense, the legal changes made in the 1970s turned a mandatory regime of taking your husband's name into a default regime. By that I mean, most women today continue to take their husband's name at marriage, but they're no longer required to do so. Traditionally, states just did not have any law about names at marriage. There's just nothing on the books, nothing in the codes that explained what happened. The marriage license has always asked for the groom's name and the bride's name, but that was basically it. What would happen is the bride would take the marriage license to the Social Security office and the DMV, anywhere else she needed to go, and she would change her name simply by showing the marriage license that reflected her husband's last name. If she never went to the DMV to change her name on her identity card, she essentially retained her maiden name. Women, though, started going to the DMV and asking for a hyphenated name or 2 last names or to move a middle name. This left a lot of discretion in the hands of civil servants, and there was no guiding state law. Civil servants also had to decide what to do about men who wanted to take a woman's name because the law was silent on that. In addition, with Obergefell and the nationwide authorization of same-sex marriage, new norms had to be created for same-sex couples. Accordingly, states reacted to these societal changes by passing laws that provided a list of name options available for marrying couples. These state laws vary quite a bit, but at least they provide some guidance to marrying couples and to state civil servants about what changes can occur on the name with names on marriage licenses. Although states have been slowly writing these types of statutes for over 30 years, South Dakota did not create one of these statutes with a list of name options until 2021. So until 2021, there is just no statute that defined names available. In 2021, though, South Dakota passed a law that allowed for certain name choices at marriage. The statute was gender neutral, which it has to be following Obergefell, and because of the Equal Protection Clause of the 14th Amendment. This 2021 statute allows a marrying person to change their last name and provided a couple of name options. You could take your spouse's name or you could hyphenate both names. But it specifically said the middle name or first name could not be changed at the time of marriage. This struck me as problematic because it is very popular for women to take a groom's last name and turn her maiden name into a middle name. In fact, women in South Dakota had been doing this for decades. Because while there is no statute authorizing that to happen, when a woman took her marriage license to the DMV and the Social Security Office, is one of the options generally just allowed to women by people who are processing name changes. Accordingly, the 2021 law took away the ability for women to keep a maiden name as a middle name. Other than that one piece, the 2021 law was a good thing. We updated our marriage licenses to have a blank line where the marrying couple actually writes down their new names. So it's worth noting that at the time you get married, you actually write down the name that you plan to use as your legal name. This seems like an improvement to me. Under the old system, there was always some ambiguity about a married woman's name. And in fact, many married women used a variety of names. I'll take my mom for an example. She was born Arlene Day and married a man with the last name of Bowling. After her first marriage, she started to use Arlene Bowling. She was then widowed in her early 20s and got tired of having the name of her former husband because people would ask her about the Bowling family, not realizing she was a widow. So then she just stopped using Bowling and went back to being Arlene Day. She didn't ask anyone about this, she just did it. Then she married my dad and she added Alsgaard as a last name. But depending on her mood and the type of situation, she sometimes goes by Arlene Alsgaard, but also sometimes Arlene Day Alsgaard. If you ask her, she doesn't quite know what her real legal name is. It might be Arlene Alsgaard or it might be Arlene Day Alsgaard. Sometimes important documents will even have a hyphen that gets added. This type of situation with ambiguity for a married woman's last name used to happen all of the time. And it happened because the marriage license itself did not reflect a name change. And that left the new name ambiguous. So I think it's a really good thing that we now have marrying couples put their names on the marriage license. The marriage license itself becomes proof of the name change. The newlyweds simply show this marriage license to the DMV, to their banks, to their airlines, and anything else to show their name change. But again, there's one glaring problem with the 2021 legislation, which was this new ban on using a maiden name as a middle name. Thankfully, that prohibition lasted only a year. When the legislature came back in 2022, they fixed the middle name portion. Now the name change statute, which is found in South Dakota Codified Laws 25-1-10.1, allows someone getting married to do the following with their name. So first, with the last name. You can keep your original last name, or you can change a last name to adopt your spouse's last name or to hyphenate both last names. Second, with the middle name. You can keep, of course, your middle name, or you can change it. The only change that is allowed is moving your prior last name to a middle name. So this means you could essentially have either two middle names, keeping your middle name and adding your maiden, or you could drop your original middle name and use your maiden name as your only middle name. And then third, for first names, you are not allowed to change a first name with the marriage license. If you want to change your first name, you have to go through the statutory name change process. So I overall think that it's really good that South Dakota has made these updates. I personally would prefer to see more name options available to people because I am not particularly worried about having more options available. Other states do provide other options, but South Dakota is not particularly out of the norm. And the other thing is that for folks who want more name change options, they can just get married crossing borders. So, for example, South Dakota has a much longer list of name change options because they have an option that allows you to blend your surnames. And so me, for example, my maiden name was Allsgard. I married a guy named Hackey. He declined my invitation to be an Allsgard. I declined his invitation to be a Hackey, and we decided to put our names together to become Hacksgard. So South Dakota, of course, would never let us do this under the old system or the new. We ended up getting married in North Dakota because North Dakota allowed us to make this name change on our license. Then, of course, once you change your name in North Dakota, you can use that marriage license to change anything you want to change in South Dakota. So if you're advising clients who want to do sort of a more expansive name change process, a number of our marrying state or our neighboring states have a lot more options. North Dakota has a longer list, although both Iowa and Minnesota have some of the most liberal laws in the nation and allow folks to take pretty much any name they want. So it's easy enough to cross the border for the official marriage license and then use that to change documents once you get back home. So I will just say this is there do seem to be two arguments that come up against broader name change law options at the time of marriage. The first one is difficulty for the registers of deeds in filing documents. I feel like this burden is simply insufficient to justify taking away personal choices because there are, of course, other ways that you can change your names. The second one is fraud. I think fraud is far less of a concern now that the name you choose has to go on the marriage certificate. Instead of situations like my mom's where the name might change based on circumstances or who is filling out paperwork, since we now require spouses to put their names on the marriage license, it is easier to trace exactly what name is being used. This also means it's harder to hide from creditors since you only have one official name. So I will also say there remains, like if South Dakota doesn't have the name options you want, you can cross state lines, especially to Iowa, Minnesota, North Dakota that have more options. You can go through the name change process that Megan is going to talk about. And technically there remains a third option, which is a common law right to change your name through usage. Traditionally, if you just started using a name and you used it long enough, we would just consider that your legal name. The problem is that in our modern era, it's almost impossible to do this. Now, every institution, and by institution, I mean everything. Think your banks, the airlines, the DMV, your employer, wants evidence of proof of your name. This means that it's functionally impossible to just start using a new age or using a new name in this day and age and use it enough to meet the common law threshold for a name change. So that's really not a practical live option anymore. And so you're kind of set up of wanting to do one of the more kind of official name change processes. And so that kind of wraps up my description of the name change at marriage. It's both simple in that all you actually do is just put your name on the marriage license. And it's somewhat complicated because states put different limits on what changes can be made, which means it's different in every state. it can be difficult for lay people to understand what name options are available unless those options are very clearly posted somewhere. And of course, they're in our state code, but that means we need to rely on folks finding the state code. But overall, I would say the name change on the marriage license is a great way for marrying couples to change names to get the names they want at marriage, which of course allows couples to express their preferences for shared family names if that is what they choose to do. So I will stop there and hand it over to Megan to continue on with the second half of this.
Thanks, Professor. Beth, can you put up my PowerPoint? Perfect. So I'm going to talk a little bit about the statutory name change process in South Dakota. And along with that, I'm also going to be talking about how to amend birth certificates to reflect name changes, and then also a somewhat timely topic as well, what South Dakota allows in terms of also amending birth certificates to change or amend the gender marker on them. Next slide. So it's important to understand, first of all, that when it comes to name changes, there's a pretty significant difference between how the law treats adults and minors. Generally, South Dakota law does give courts pretty broad authority to change people's names. When it comes to adults, those laws are geared mostly to ensuring that creditors don't get confused. We want to make sure that our law does not allow people to skirt their obligations simply by changing to a different name. And so when it comes to adults, primarily an individual must establish residence, which under SDCL 2137.3 is 6 months in that particular county before filing the petition. And then also adults must give public notice as well in order to ensure that any creditors that are out there might be aware of the change. And that notice must state the time and place of the hearing on the name change, as well as both the old and proposed names, and be published once each week for 4 successive weeks in any legal newspaper of the county of residence, which Tom referenced as we were getting going here. Minors, as I mentioned, are treated much differently. Rather than, for obvious reasons, being a concern related to creditors, it's important to understand that naming rights are, in fact, an aspect of legal custody of children. And we'll talk a little bit more in terms of what that might mean, particularly if it's a contested name change for a minor as between divorced or separated parents. So when it comes to minors, again, we have a residency requirement, which is again 6 months. But the primary concern for minors is whether the name change is something that's going to be in the best interest of the child and or whether there's parental consent. The statutes also do contemplate some notice for name changes of minors. However, there are exceptions to that requirement as well, given privacy concerns for minors. Next slide. So as I mentioned, I'm going to talk a little bit about not only how to change the name, but also how to go back and change the birth certificate to reflect that name change once you get the court order to change the name. So first of all, a birth certificate is a highly regulated document under South Dakota law. There's a number of both statutes and administrative regulations that relate to birth certificates. It is generally considered to be a public record of the birth, and it's the Department of Health's Office of Vital Records that handles the registration of births. And we'll talk in a little bit more detail how that office becomes involved once you get the court order to change the name. And ultimately, it's the Office of Vital Records' responsibility to prepare and preserve the birth certificates. And so really what that means is that even if you do obtain a court order to change the name or a gender marker, your job isn't done. And so there's one more step that needs to be taken through that Office of Vital Records to complete the change. Next slide. So there's a difference between new birth certificates and amended birth certificates under South Dakota law. And those differences are really important when it comes to name changes and gender marker changes, because it impacts how you're going to want to word and draft your pleadings. So under South Dakota law, a truly new birth certificate can only be issued in two situations. First, an adoption, or secondly, a paternity that's legitimized by marriage after the issuance of the original certificate. So the original birth certificate is sealed, filed, and then can only be opened with a court order or by the Secretary of Health. In any other situation, including a name change through a court order, the birth certificate is considered an amended birth certificate for purposes of South Dakota law, not a new birth certificate. And again, that's an important distinction, and that's an important word of art or term of art that to be aware of when you're drafting your pleadings. Next slide. In terms of how and when the birth certificates then can be amended, there are a series of administrative regulations that have been put together by the Department of Health that set forth the situations how and when a birth certificate can be amended. And typically there's two methods for doing so. The first one is an affidavit of correction, and the second one is a court order. Next slide. So in order to amend the birth certificate through an affidavit of correction, the affidavit must include very specific information that is set forth in the statutes. First, there needs to be in that affidavit sufficient information to identify the certificate. Most significantly, that would be the name that's reflected on the original birth certificate, the date of birth, the place of birth, and also the mother and father that would be listed on that birth certificate. Additionally, the affidavit of correction will need to set forth what information is on that certificate that is incorrect. So if the father that's listed is incorrect, if the date is incorrect, if the place of birth is incorrect, any of those sorts of things will need to be included. And then finally, also setting forth what the correct data should be on that birth certificate. There are very strict requirements on the supporting documents that could be submitted for this request. And so if you are going to be doing an amended birth certificate through an affidavit of correction, you'll want to go through those administrative regulations and make sure that you are complying with those strict requirements. Next slide. So in terms of what supporting documents you'll need to submit with that affidavit of correction, it really depends on really how old the original birth certificate is. So if the original birth certificate that you're trying to correct is 1 year or older, then you will need one or more supporting documents. If the birth certificate if the child or by extension birth certificate is under 7 years old, then you'll need documents dated 1 year before the application and within 1 year of birth. And then finally, if the child is 7 years or older, then you will need documents that are dated 7 years before the application and within 3 years of birth. And so that's kind of like an LSAT exam a little bit there in terms of figuring out what types of supporting documents you'll need. But that's one of the first questions that you need to look at is how old is this child, and then reference back to those administrative regulations in terms of what documents that you will need. And then finally, you'll need for those documents, it has to be an original, a certified copy, or an authenticated copy, or some signed statement from the custodian of those records. If the validity of any of those documents are questioned, or if any of those strict requirements that are set forth for the affidavit or the supporting documentation are not met, then the application might be rejected. So as you can see, not only are there very, very specific requirements, but if you don't comply with them within the letter of the law, then that can be a basis for rejecting that application. So affidavits by correction generally are a fairly difficult process to go through. Next slide. Now, of course, the procedure that most of us would be familiar with would be the amendment process through a court order. And so I'm going to walk through that process a little bit as well. Typically, the name and gender marker changes cannot meet the strict requirements for an affidavit by correction. If you recall, the purpose of a affidavit of correction is to correct incorrect information on the original birth certificate. And so if we're changing the name or the gender marker change through a court order, that's not considered incorrect information under the affidavit of correction process. So those types of changes on the birth certificate need to be done through the process of amendment by a court order. So again, this process requires enough information to allow the Department of Health to identify the certificate that's going to be amended, the incorrect data as it's listed on the certificate, and then additionally the correct data as it should appear. And it's important to note here that the documentary requirements for affidavits of correction do not apply to the process for amendment by court order. So that mind teaser in terms of how old the documents must be and how many of them you might need depending on the age of the certificate does not apply if you're trying to amend by court order. But there are some other requirements in terms of the information that should be provided, particularly as it relates to gender marker changes that we'll talk about here in just a minute. Next. So this is really the crux of the issue, particularly when it comes to gender marker changes. The current Department of Health regulations do not define what is meant by incorrect data for purposes of the amendment by court order process. So the Department of Health has previously indicated, although informally, that a person who has transitioned to a different gender later in life does satisfy the incorrect data requirement. And under this view, the birth certificate is seen as a means of current identification and not merely a historical record. And there is some case law in Minnehaha County that has embraced this view, although there are decisions from other circuits that have not. And so, I think it is wise before you embark on this process in any particular county or circuit to try to find out whether there are any decisions on this particular issue in that circuit or county before you go down this road. I have had success in Minnehaha County doing it because, like I said, there is some case law out there, and but I do know that other circuits have not been quite as friendly to this process. And so that's really what it comes down to. And I think that's a really fundamental question here is what is the purpose of a birth certificate? Is the purpose of a birth certificate for the Department of Health to keep historical records of where children are born, and how many children are born and how many children of each gender are born at a particular time and in a particular place, or is the purpose of a birth certificate to be a means of identification or a piece of paper that identifies you as you go forward in life for all sorts of legal purposes? Because if it's the latter, as the Minnehaha County Court has recognized, then any individual who has transitioned to a different gender needs to be able to amend that birth certificate to allow them to currently identify themselves. Next slide. And of course, in many cases, if people are going through the process of changing their name and then going back and also amending the birth certificate, in many cases, their goal is to then obtain a birth certificate that appears as if it is the original birth certificate. At the end of the day, most people want to be able to have a birth certificate with the new name and perhaps the new gender marker on it that looks just as if that was the birth certificate that was issued to them on the day that they were born. And again, as we talked about earlier, you can't truly get a new certificate. That's a very strictly regulated process that can only be done in the situations of an adoption or of confirmed legitimacy. And so how do we go about getting an amended certificate that appears as if it's a new one without actually getting a new one? And here the language of the rules isn't exactly clear. The rule states that a new certificate created by a court order will not be marked as amended, but only amended birth certificates are created by a court order. So we have this weird situation where the rule is referencing new certificates created by court order, but as we know, you can't actually get a quote new certificate through the court order process. You can only get that in those two limited situations that we talked about. So at the end of the day, if that's the goal of your client, which in most cases it is, it's really important that when you're drafting your pleadings and your motion that you specifically say that the new, or not the new, the amended certificate not be quote marked as amended, and that the original birth certificate be sealed. And that way, when the Department of Health issues the birth certificate with the changed name and the changed gender marker, then it will not have that tagline on it that says marked as amended. And there won't be any way for someone to pull the original birth certificate to compare to see that it's been changed. So how do you actually go about doing it? First, we'll talk about the process for adults, and then I'll separately talk about the process for minors. So for adults, I think it's helpful first to just run through what the particular pleadings are that you'll need to draft in order to start the process. So first, for an adult name change, you will need a verified petition for the name and, if appropriate, the gender marker change. You will need to include the original birth certificate and any other supporting information such as evidence of residency. If you are going to be doing a gender marker change, then you will likely also need a letter from a treating physician that details what treatment that person has been undergoing and where they are in that process. You will also need to prepare a notice of hearing to set the petition for hearing in front of a judge in the county where the individual resides. You will need to do an affidavit of publication for purposes of the name change. And then you'll also need to do proposed orders as well, including a reference to the gender marker change and statement that the birth certificate not be marked as amended and that the original be sealed. So one little practice tip that I do here is keeping in mind that individuals who are changing their name and their gender marker at the same time have some really significant concerns about privacy and retribution. I try to keep this process as sensitive to those concerns as I can. So when I've done them, I've actually broken the petition out into either two petitions, one petition for the name change and one petition for the gender marker change, so that I can do separate notices of hearing for the same time. Or I've done it all together as one petition, and then I've done separate notices of hearing. Because when you're publishing in the newspaper, you only need to publish the notice of hearing. You don't need to publish the entirety of the petition. And so if you can do two notices of hearing, then I would publish the one for the name change, but not necessarily the one for the gender marker change. And of course, you can still sometimes tell based on the name change that's being asked for that it's also a change for a gender marker, but it's not nearly as explicit. And so to the extent that you can take that step, I think that's always appreciated. And also one of the benefits too of doing the separate petition for the gender marker change, because there aren't the notice requirements for the gender marker change as there are for the name change process, you could potentially also do a motion to seal that petition and or a petition, especially to seal the attachment, the attached letter from the treating physician, as they might want to keep some of that information private as well. Next slide. So then the final process for changing the name and or gender marker change for an adult is to prepare for a hearing before the judge in open court in your county courthouse. And again, if it's a name change, that has to be a public process. And so sometimes I think it's good to have that counseling with your client if there's going to be a gender marker change process so that they do know and understand ahead of time that it will be a proceeding in open court. The judge will review your petition and filing, and if statutory requirements are met, the judge will then sign your proposed order right there at the hearing. Like I said, I've done this a couple times in Minnehaha County. I've not met with any resistance from any of the judges here when I've gone through the gender marker process. But my suggestion would be that if you are going to be going to one of those hearings, particularly if it's a judge that's not seen that done before, you'll want to be well prepared with some of the decisions from the other circuits and the administrative regulations so that you can argue those points under the law to explain that this is something that is currently allowed under South Dakota law. Once you obtain the judge's signature on those proposed orders, I usually take them right down to the clerk's office and have them filed. And then I obtain 3 or 4 certified copies of that order from the clerk's office. You'll want to then do a notice of entry of that order. And then the client will need those certified copies in order to present those to the Office of Vital Records to actually obtain the amended birth certificate. And then they may also need those certified copies to take to other agencies like the Driver's License Bureau, Social Security Administration, and all those other agencies to get those documents changed as well. Next slide. So I also talk here a little bit about minors because, as I mentioned, the process is a little bit different for minors. And first, I just want to talk about the situation in which the name change process for a minor is uncontested. I mean, it's not contested by the other parent. It's much similar to the process for adults, although there are some important distinctions. So like with adults, you'll need a verified petition, including the original birth certificate and other supporting information, such as residency and facts to support the idea that there won't need to be public notice because this is a minor. And once again, if you're asking for a gender marker change, you'll also need that letter from a treating physician. Notice of hearing, notice of consent. That is something that the law requires for a minor if over the age of 12. An affidavit of publication proof of service, and the proposed order or decree, again, including the reference to the gender marker change and statement that the birth certificate not be marked as amended. As I mentioned before, there's always concerns with privacy, particularly with minors. And the South Dakota Law 2137-5.1 does allow for a name change not to be done publicly for minors if certain conditions are met in order to maintain the privacy of minors. Next slide. And again, the process for completing the uncontested name change for minors is much like it is for adults. You'll have a hearing before a judge in the county courthouse. If the proper showing has been made in the petition under SBCL 2137-5.1, that hearing though will not need to be made public. Again, the judge will review the petition and filings, and if the judge believes that the statutory requirements are made, the judge will likely sign the proposed order at the hearing, and then much of the same process. You'll want to file that order with the clerk's office, obtain 3 or 4 certified copies, file the notice of entry, and then work through the Office of Vital Records to actually obtain the amended birth certificate. So as I mentioned, the process is much different if it is contested. As we mentioned at the beginning, the ability to change a minor's name is an aspect of child custody. It's an aspect of legal custody. And so if there is going to be an objection by the other parent to a name or gender marker change for a child, then it will simply proceed as a full evidentiary hearing before a judge to determine whether that name and gender marker change is in the best interests of the child. If that motion for the name and or gender marker change is granted, then you'll simply follow the procedures set forth in the prior slides in terms of getting the order signed, filing the notice of entry, and then working through the Office of Vital Records. And then just finally to recap, because I think particularly with gender marker changes, privacy is so important. You again can ask that the original birth certificate be sealed. And if the goal is to obtain a birth certificate that looks as if it was the original birth certificate, and if there's to be truly no paper trail that the birth certificate has been amended, then it is often a good idea to ask that that original birth certificate be sealed. For minors, you can ask that no affidavit of publication be done, and you can ask that that particular hearing not be open to the public in order to protect the privacy of the minors. However, understand that court filings will be publicly available unless you do a motion to seal and the judge grants that. So if there is an individual that wants to visit the county courthouse and pay a fee to access those records, they certainly can do that, but it will be much more difficult for them to obtain them. Any questions?
I have a question. This is Tom Keller.
Yeah.
My understanding is minors, and it comes up most with an unmarried couple who they, let's say, use mom's birth name as the last name of the child and subsequently get married and then want the child to have the last name of the father if the mother takes that name.
Mm-hmm.
That can be done without any publication. There's a consent statute. Is that right?
Yeah, so for any minor name change, let me just pull up the statute. You will, yeah, it's 21-37-5.1. If the child has been a resident for 6 months, if the minor child, if 12 years of age or older, gives written consent, and if it appears that the name change is in the minor child's best interest, then you don't need to do the notice.
Okay. I mean, that's the way I've always kind of done it. The other side of this, and maybe this is more of an advocacy question, is sometimes the unmarried couple will use the father's name for the child, and then the mother will approach a lawyer asking to change the name back to that of the mother. Generally, I've found courts will not do that in most situations if the father appears and objects.
That's my experience too. Yeah.
Yeah, but so, I mean, just something to think about, that if there's gonna be an objection, sometimes, again, if you're on the side of the father, to bring in a grandparent or something to talk about the importance of the surname in the family. And also, there's an argument, at least, that should the mother eventually marry and take on the name of her new spouse, that the child would not have the name of either parent. And that can be persuasive as an argument as well. I did have one other question too. Sorry to take this over, but you talked about notice of entry, and who do you give notice of entry to on a name change?
It's a good question. I guess if it's so for adults, I haven't.
I don't think
I
there is one. Yeah.
Yeah. And then for children, you know, I guess when I've done the name and or gender marker changes for children, there has been a parent on the other side who did not object, but was out there. And so when we got the order to change the name and or gender marker, I at least gave that other parent then the note, or served them with notice that that order had been entered, just so that they were aware of it.
Thanks. I appreciate it, both of you.
It's a really interesting process, and I've given this presentation before, particularly on gender marker changes, and it's always surprising to me. I've been waiting every legislative session for something to come up to change those administrative rules to make that process not available anymore, but you can still do it. So. That's all I have.
Does anyone have any other questions for either of our advocacy questions or practice questions for anyone? Well, I will say thank you again so much for attending, everybody. Again, feel free to email people too. One of the benefits of this is the close-knit community that we have in South Dakota amongst the bar, and the ability to continue to reach out and mentor others. And this is an important part of that process. And on behalf of everyone on the CLE committee and the speakers, I appreciate everyone's time today. Thanks.
Thanks.